Dear guests, I'm glad to welcome you at our today's webinar that is called "The Future is Now, the New World of Work in Russia." Your today's host at the webinar will be myself, Ekaterina Ilikchan. I'm a senior associate with the employment team of CMS Moscow office, and my colleague Irina Skvortsova, who is also senior associate with the same employment team.
Hello.
During this webinar, we will discuss various issues related to new world of work and COVID-19 related matters, such as staff mobility. Irina will also discuss remote work and in particular new rules that came into force just from January 1st of this year. Also health and safety measures related to COVID-19 and how to prepare for an audit by the authorities. That can check this compliance with these health and safety measures. And finally, very briefly, we will discuss vaccination and COVID-19 tests for employees. As you may know, in Russia currently, we do not have any lockdown or work from home requirement, but still, as far as we know, many employers and international businesses, they continue with the remote work arrangement, or they allow some flexibility for employees so they can decide whether to work from office or from home. Like, for example, in our office, we come to the office when we need to, but generally we work from home still. And also there are various regional requirements. In Moscow, in particular, there is a requirement to keep certain categories of employees on remote mode. These are employees so-called vulnerable categories. For example, employees over 65 years of age, or pregnant women, or employees with certain diseases. They should continue to work remotely. First matter that I would like to discuss with you is staff mobility in Russia during COVID-19 pandemic times. First of all, internal staff mobility was not affected by COVID-19 just simply because of the fact that it is not very developed in Russia. Therefore, it's not very common for employees to relocate to another city. It happens though, but it's not very common situation. As for business trips, they are not prohibited. Employees can go on business trips, but still many employers are limiting, restricting business trips, and they send employees to business trips only if it's absolutely inevitable. For example, if an employee needs to do some physical work to install some equipment, for example, then of course business trip is allowed, but still, as we see, many companies continue with online mode and resolving issues via tools we are used to by the moment with Teams, Zoom, and similar tools. As for international mobility, well, this area was affected by COVID-19, and currently international mobility is very, very restricted. In terms of business trips, citizens of some countries can enter Russia on business visas, and as well as other types of visas. From other types of, based on other types of visas, and these are citizens of countries from the list with which Russia opened flights. There are 23 countries in the list, but one of them is UK, with which later flights were again temporarily suspended, but this temporary suspension lasts for 2 or even 3 months for now. So in fact, there are only 22 countries. Also, there is additional category of technical specialists. These are employees of foreign companies that produce or supply equipment to Russia, and Russian customers can invite them to Russia to install equipment or to maintain, repair it. But it's not straightforward entry, such foreign citizens, they should be added into special list of special pre-approved lists for entry, and Russian customer should in advance apply to its profile ministry, let's say to Ministry of Production and Trade or some other ministry, to add this foreign specialist into the list. Then they can enter. What I would advise to allow sufficient time for the procedure, I think it can take from like 3 weeks to, in some cases, 6 weeks or even more. So you need to plan in advance such visits. As for employment and relocation, it is also restricted. Employers can hire, regular employers can now hire, I think, only one category of foreign employees. These are highly qualified foreign specialists. Again, it's not a straightforward application, because employer should first apply to its profile ministry to add these foreign specialists into approved lists for entry. But then they can apply for work permits, receive them, and those foreign employees can enter Russia. Also, a couple of weeks ago, government added another category. These are workers added again in the special list by Federal Service for Labor and Employment. But based on our understanding, this category is was introduced for construction workers who work on priority sites, and lists will be approved on government level, so it will not be available, I think, for regular employers.
Ekaterina, and what will be if a highly foreign specialist is from the country that resumed flights with Russia? Can the employer hire such an employee without obtaining an approval?
Well, there is a clarification from the Russian Ministry of Internal Affairs that no, unfortunately, it's not possible to hire such employee without prior approval. Employers still need to apply for this list, so for the foreign specialist to be added to this approved list, and then they can hire them and apply for a work permit. As for current highly qualified specialists who already have work permits and visas, situation is not that straightforward, and there are two opinions on this issue. Some authorities say that if this highly qualified specialist is from a country with which Russia resumed flights, then he or she can enter Russia without any additional approval. But there is another more conservative opinion saying that no, still you need to be in the list to enter Russia. Based on practice, I know that foreign specialists from these countries, they enter Russia without prior approval, but you never know what would be opinion of the border control officer who takes the ultimate, the final decision. So the safest approach would be, of course, to add to the list. But as I said, in practice, it worked even without prior approval.
Thank you. Well, now let's speak about, sorry.
No, that's it. I'm giving floor to you, Irina.
Thank you. Well, remote work is now a part of our life, although previously it was not widely spread in Russia. Now we have new rules on remote work effective from the beginning of this year. These new rules were adopted to adapt legislation to the current realities and to the business needs. The new rules are quite extensive, so during today's webinar, we will be able to discuss on the key changes. Such key changes include the following. First of all, the term of remote work that didn't exist previously in the labor code now is equated with the pre-existing concept of distant work. So now remote and distant work mean the same. Employers are now allowed to transfer employees to distant work not only by entering into an employment agreement with them, but also by an addendum to the employment agreement, and in some specific cases that we will discuss later, by an internal company regulation. Previously, the state authorities believed that it is not possible to transfer an employee to distant work by an addendum, and the employer had to dismiss the employee first and then hire the employee on terms of distant employment agreement, and of course it seemed to be nonsense. Another change that was welcomed by the business is the possibility to enter into mixed contracts when an employee may work both remotely and in the office. And previously it was not possible without creating specific risks for the employer in terms of labor safety and employee performance control. And finally, it is now possible to define the term of such transfer. The employer and the employee may agree on transfer to distant work for indefinite or definite period. And in the later case, the addendum on distant work cannot exceed 6 months, but it may be renewed an unlimited number of times.
Well, and Irina, and could you please explain why such a 6 months limit was introduced for temporary distant work?
Well, some experts who participated in the legislative initiative say that it was done to allow the employees to change their mind if they later find such an arrangement for them not convenient for any reason. So upon expiry of this 6-month period, the employee may refuse to prolong it and return to the office. So it is for the benefits of the employee, but creates additional paperwork for employers on renewal of this arrangement.
Thank you.
Okay. And there is also a good tendency to simplification of electronic document flow. In particular, for most of documents, it is now allowed to use a simplified electronic signature. That means that the employer and employee may confirm sending and receiving documents by entering a login and password. And further, the employer may work out another form of interaction with the employees, but this another form is, of course, to be set in the employment agreement or internal policies. And of course, it's to allow the evidence that the document is received or sent by a particular employee. But some documents still need to be signed by enhanced electronic signature if the parties choose to enter into the agreement in electronic form. Such signatures are issued by certification centers, and in practice, employees in most cases refuse to receive these signatures, and that is why generally the employers and employees sign the employment agreement and then the two in paper format rather than in electronic form. And by the way, the Ministry of Labor is now developing amendments to the Labor Code that will allow to extend the electronic document flow to all employees and not only to remote ones. Well, and in the next slide, I have included the list of issues that should be regulated either in the employment agreement or in the internal document. Well, it is very important to regulate all these issues as detailed as possible. And as an example of how it is important, if you do not set working hours in the employment agreement, then under law, the remote employee may work at any time at his own discretion. And so if you call to this employee in the middle of the day, he may theoretically not answer you. And further, he may choose to work late hours or on weekends, and who will be responsible for that? Will the employer have to pay for that? The state lab inspections believe that no, but I'm not sure that the Russian courts will be of the same opinion. By the way, in the current law, there is no employee right to disconnect, as in some European countries. It is interesting that the statistics say that employees in Russia who currently work remotely generally work 2 hours more on each day. If you do not set the region in the documents where the employee is to perform his job duties, then there may be a situation when the employee moves to another region, for example, from Moscow to Vladivostok, and as a result, the employer will be required to pay no benefits to such employee. We also recommend listing in the employment documents the equipment, software, and hardware that the employee must use during his work. If the employee does not require scan, print, office supplies during his work, then the employer doesn't have to provide them to him and doesn't reimburse the employee for purchase of such. If upon agreement with the employer, employees use their own equipment, then the employer is to compensate the employee for that, and the amounts are to be agreed in the employment agreement or internal policy.
Irina, you mentioned that employer should compensate employee for use of equipment owned or leased by the employee, but what about electricity and internet expenses incurred by employee while working remotely? Should employers compensate for that?
Well, when employer and employee agree on remote work, then the law doesn't require to compensate the employee for internet connection or electricity. But as a matter of practice, employees are generally reimbursed for the internet. But the amount may be nominal and agreed to by the parties. The Labour Code now also provides two additional grounds for dismissal of remote employees, in addition to the general ones. The first one is, so to say, for absenteeism of remote employees. But please note that you cannot terminate a remote employee if he is silent for 4 hours as an office one. You may terminate a remote employee only if he doesn't interact with you for more than 2 consecutive working days. And in my opinion, this makes such a rule, such a provision non-practicable. And before termination, you will need to request a written explanation from that employee, and of course, the employee may explain this solace from his side by a non-working mobile phone, for example, or poor internet connection. And it will be your task to prove that the employee had a possibility to contact you using other means. And ideally, these other means should be listed in the employment agreement or internal policy. And the second termination ground refers to the situation if you hire an employee for work in a specific region, and if he moves to another region where you do not need a representation. In this case, you may dismiss such an employee. And I also need to draw your attention to the fact that previously employers were allowed to enter into the employment agreements additional grounds for termination of remote employees. Now it is not possible. So you need to review the employment agreements with decent employees and update them and delete those grounds that are not provided by the Labour Code. Well, earlier I mentioned that employees may be transferred to decent employment not only by an addendum to his employment agreement, but also by internal company regulation. This is provided to cover the situation that we had in spring 2020, when we had to transfer employees to decent work almost within 1 day without having a possibility to negotiate addendum to their employment agreements. So if there is an exceptional case or there is a specific statutory act, the employer may temporarily transfer employees without their consent to distant work by issuing an internal company regulation. That may be, for example, in an HR order. The employer needs to familiarize employees with such document in the way allowing to evidence that the employees have received it. This internal company policy should regulate all the issues that we have previously discussed with you. And for any reason the employee cannot work remotely, then this period is declared as idle time, and during this period the employee is to be compensated at 2/3 of his base salary.
Irina, and could you please sum up what employers should do in connection with this new law on remote work in general?
The employees need to check how this work is currently formalized in their companies, and they need to update their employment agreements, for example, in terms of the term of the distant work and additional grounds for termination, and work out specific internal regulation that will establish rules on interaction between the employer and the employee. Well, and finally, we would like to talk about labor safety requirements. They are minimal for remote employees. You do not need to inspect their working places at home, and you do not need to provide them with some specific ergonomic chair or table. The only requirement is to familiarize them with the rules on use of their equipment that you provide to them, to investigate and to properly document on-the-job accidents if they happen while the employee works remotely, and to ensure employee statutory accident insurance. But the situation changes significantly if a remote employee comes to the office. In this case, the employer needs also to comply with all general labor and safety requirements, and even more due to the epidemiological situation. And Irina will tell you more about such new requirements.
Yes, due to COVID-19 pandemic, Russian health authorities developed additional requirements to health and safety, and introduced health and safety measures to be observed by employers. Here on the slide, I listed general requirements, but I would advise you to check if there are additional requirements for your particular industry. For example, the authorities approved specific requirements for retail industry and for some other industries. I will not read these measures listed on slide, but what I would like to discuss is how authorities can, I would say, creatively audit companies and check for compliance with these measures. For example, employers should provide employees with masks, and employees should wear them and change them every 3 hours. So in case officers come to audit your office in the afternoon, and by the time employees should have changed masks, they will look into trash bins near employees' desks, and if there are no masks packed in 2 bags and tightly closed, they will assume that employees are not changing masks, and this could lead to imposition of an administrative fine. Also, same with disinfection. We have heard that officers come to an office and check if there are empty bottles of disinfectants, or at least opened bottles used in part. So if there are none, again, they are assuming that there is no disinfection being conducted as required. For bacterial air irradiators that should be installed at premises, as well, authorities could check if they are enough for this particular space, because every device is designed for a certain space, and officers could come with a ruler and measure your premises to check if this particular device is covering your space, and if, for example, it covers 25 square meters and you have 26, again, they could consider this as a violation of requirements and non-compliance with them. What we would recommend to do is to try to pass this inspection without fine. As some of you may know, in Russia, everything is about paperwork. So what we would advise to do is to have all the rules on paper For example, you can approve orders and develop internal policies on all these measures, what employees should do, what every employee should do, and most importantly, you should provide these documents to employees for signature against signature for acknowledgement. And this could help you to defend company. For example, if officers, inspectors come and see your employee without mask, where he or she should wear it, if you have these orders and regulations signed by employee, then you at least can try to tell that it's not employer's fault, and this is employee's fault who was acknowledged with the rules but failed to comply with them. Also, you need to maintain various registries to confirm compliance with the measures. For example, when I come to the office, first what I do is signing various registries. For example, temperature measuring. I confirm that yes, my temperature was measured. Then I sign another registry confirming that I received masks for a day and gloves. As well, other employees are signing registries to confirm disinfection and cleaning. So all these registries should be maintained at your office and kept, and should be filled in every day when you have employees working from the office. Also, what is important is to keep all accounting documents confirming purchase of these required items such as masks and gloves and so on. Some of items require certification, like disinfectants and bacterial irradiators. So for them, when you purchase these items, please ask seller to provide you with a copy of relevant certificate, and please keep them on your file and to be ready to present to authorities if they audit your office.
Ekaterina, do you know how often authorities audit the companies?
Well, as far as we know, they mainly audit large companies for now with many employees, and this is understandable because risks are higher at such offices or plants or factories. But you never know, and they can audit, of course, mid-size and small offices as well. But chances, in my view, are a little bit less for small and mid-size offices and sites to be audited at the moment.
Thank you.
So, and the last topic that we would like to discuss briefly is vaccination and COVID-19 tests for employees. As you may heard, we have one vaccine publicly available in Russia, it's Sputnik V, and 2 other under approval process as far as I know. But these vaccines are currently not mandatory for regular employees. You as employers can encourage employees to vaccinate, to recommend them to vaccinate, but you cannot generally enforce them to do so. Vaccination can be mandatory, but only in certain cases for some employees, if they fall in the approved categories on the national vaccination calendar, plus if these employees perform work that related to high risk of being infected. For example, such employees are employees of educational institutions or some medical workers who work with infections. The list of job positions is approved by the government, so you can check with this list to be sure if you can request your employees to vaccinate or not. But for general office employees, vaccination is not mandatory for now. And the last topic is COVID-19 tests. Again, there are approved lists of persons who should pass these tests. Some rules are applicable on federal level. For example, Russian citizens who come to Russia from abroad, they should pass this test within 3 days upon arrival. And foreign nationals, they cannot even board plane to Russia without having negative COVID-19 test. And in certain regions, like for example, we have in Moscow, there are additional requirements. In Moscow, employers should ensure testing of at least 10% of their employees every 15 calendar days. Maybe in some other regions there are also similar requirements, so you need to check in each particular region which requirements apply.
Ekaterina, and should employer test also employees working remotely or only office employees?
For now, we have clarifications from the state authorities, from Moscow authorities, and also from Ministry of Labor, saying that this testing is mandatory only for employees who are physically in the office. So for remote employees, it is at discretion of the employer. So it's up to employer to decide whether to test remote employees or not. But in practice, of course, employers normally conduct tests for employees who are in the office.
Okay.
So this is all what we wanted to discuss during our presentations. And now we will be glad to answer your questions. If we don't answer your question during this webinar, we will return to you later, very shortly after it, with written response. So don't worry, we will respond all questions that we receive.
Okay, let me start with the first question. Can we reimburse remote employees for the use of their equipment, internet, etc. at a fixed rate? Yes, you can. The Russian law doesn't provide any regulation on the amount, on the form of payment, so you may provide for an employment agreement or internal policy any rules as you find appropriate for your business. So it may be a flat rate, or you may agree with the employee that the employee will provide you with checks. So it may be some nominal amount. So it's up to you and subject to negotiations with the employees. Well, there is one more question related to my part of the presentation. Could you please re-explain the 6 months limit to remote work? Is it a trial period according to which the employee can change his mind whether remote work is permanent or temporary? Or is it the maximum or minimum duration for temporary remote work? The employment agreement at distant work may be permanent. In this case, there are no limitations as to its duration, or temporary. And if you agree with the employee on transfer to distant work for definite term, then this definite period may be up to 6 months. After these 6 months expire, then you may agree with the employee on a new term of distant work. And each time the new term will be not more than 6 months. So in other words, each time the addendum on distant work will be concluded for 6 months period. I hope I have responded to your question.
I also have questions to my part. I will read it now. Can we suspend employee from work if he refuses to pass COVID-19 test? Yes, you can, but only in case if this COVID-19 test is mandatory for the employee. For example, you have Russian national employee coming from abroad, then you suspend him from work at the office until he receives negative COVID-19 test. If this testing is not mandatory, then no, you cannot suspend employee from work, because employee can refuse to pass this test if it is not mandatory under legislation. I have another question for my part. What if employee belongs to vulnerable category and should work remotely based on Moscow Mayor decree, but we really need him to be in the office? Well, in such case, there is a carve out from the decree saying that if this employee's presence at your office is crucial for your business, for your operations, then you can have this employee working from the office. But I would advise to be very careful to really really consider if it is required for such employee to be every day at the office, or maybe he or she can come on certain days just to decrease risks for health. And also, I would advise to issue internal order with stating why this employee should be at the office, stating these reasons, because if something happens, then the authorities may conduct an audit of your company, and if you have these grounds fixed, then it would certainly help you as employer.
In practice, can we agree on an allowance for remote work to compensate for internet and electricity? If so, is there a recommended amount per day? Yes, you may agree on an allowance for remote work, but I would recommend you to specify that this allowance includes any expenses that the employee may incur during his work remotely. And there is no statutory amount, and you may specify that this will be a monthly allowance paid on a monthly basis. I think it will be more convenient than to establish a per day allowance. But if your employee works both in the office and remotely, then yes, I would agree with you that per day allowance may be better.
I can answer another question that arrived regarding my part. There is a question who are vulnerable employees for which work from home addendum is not necessary for now. Well, I think there is some misunderstanding. Vulnerable employees, they should work remotely based on Moscow Mayor Decree. So addendum on remote work is required for them. These employees are employees over 65 years of age, also pregnant women, and also employees with certain diseases such as, for example, diabetes or asthma. There is a list approved by Moscow Department of Health with exact list of such diseases. There are quite many diseases on the list, so you need to check if your employees have unfortunately such diseases, so then they should be working remotely. And also there is one related question: is the obligation still valid in Moscow area to have 30% of employees on remote work? No, this obligation was cancelled some time ago, but there is still a recommendation to have the 30% of employees on remote work mode, but it's at the employer's discretion whether to have them working remotely or return them to the office. At least for now, it's only recommended, not obligatory.
Екаterina, do you have any other questions on your part?
Well, I think, yes, there is one question regarding health and safety documentation, if it should be in Russian or it is okay to have it in English as professional language. The question is simple. All mandatory documentation, it should be in Russian language or in bilingual format. It can be Russian/English, but Russian is mandatory in order to comply with requirements.
Okay, well, it seems to me. Sorry.
I have just one more question arrived now regarding foreign employees. Please give us more information regarding arriving in Moscow for foreign nationals, business trips, tests, quarantine. For now, all foreign nationals arriving in Russia, they should have negative COVID-19 test while boarding the plane, so they cannot arrive without having this test. This test should be done not more than 72 hours before boarding plane, and it should be either in Russian or in English. So if it's done abroad, I think it will be in English, and if you have foreigners coming from non-English speaking country, please make sure that they're able to obtain such certificate in English, because we faced such situation in recently when in France people had to search for a medical institution that was able to issue a certificate in English. So if you are planning some business trips, then be prepared to provide such tests. As for quarantine, currently there is no obligation to stay on this 14 days quarantine for business travelers, but there is still such a requirement for those foreigners who arrive for employment purposes. So if they arrive under work visa, then they should stay on quarantine despite they have a COVID-19 negative test. Unfortunately, this requirement is still in force for now.
Mm-hmm. Well, thank you. I think that we have addressed all questions, but if we have missed any, we will respond to you in writing. Well, this brings us to the end of our today's webinar. Thank you for joining us today, and please complete the survey that will open on closing, and do not miss our webinar next Tuesday, which will focus on Singapore. Thank you very much once again, and have a nice evening.
Thank you, bye.